My name is Dana Goldman. I'm the interim dean in the Price School of Public Policy, and we tend to have a series. Well, we do have a series, which are conversations with the interim dean. And as those of you who know me, you know that I really like to speak. But I also will admit that there are some areas where I think it's better if other people speak, and this would be one of those topics. I'm very pleased that we could have our guest, Thomas Mitchell, which Richard Green will introduce, to talk about some issues related to minorities and property rights. And Richard, I'm just going to turn it over to you, and I'll be available to do the Q&A.
Dana, thank you very much. It's my great pleasure to be able to spend the next hour with Thomas Mitchell talking about work that he has been quite passionate about and successful with for going on 20 years now. I first got to know Thomas when he was a graduate student at the University of Wisconsin-Madison School of Law. From there, he moved on to faculty, where we were colleagues together. And one of the things I love to say about people like Thomas is I knew them when, and I could see how smart they were before they had it stamped on their forehead as being a really smart person. And the stamp that Thomas got a couple of months ago was to be named MacArthur Fellow for this year. And needless to say, it's always a source of great pride when you get to work with someone who ultimately gets that designation. Thomas wrote me into a project in about 2002, funded by the Ford Foundation, looking at Black landlords in the South. And it led us on an adventure where we visited courthouses in Mississippi and Eastern North Carolina to look at how property changed hands, in particular between African-American farmers and white farmers over the course of the previous 100 years. And I'm not going to say much more about it because I don't want to steal Thomas's thunder. But it led to a series of work that Thomas has spearheaded, both academic and legislative, on the implications of Black land laws and policies to make sure it doesn't happen again. And I think it's worth underscoring the following point. I think everybody knows that Black people in the US have had much less opportunity when it comes to acquiring property than white people, going back to the beginning of this country's history. But beyond that, Black people have actually had their property taken from them in much greater numbers than white people. And to give an example that's somewhat different from what Thomas has worked on, if you look at the Homeowners Loan Corporation, which was a New Deal program put in place in order to allow people who are behind on their mortgages to stay on their homes, people who lived in neighborhoods that had large minority populations were not able to take advantage of that program, and so they tended to lose their houses, whereas people who lived in neighborhoods with large white populations were able to take advantage of that program, and so were able to retain their houses. So part of the reason we see a gap in wealth between Black folks and white folks in the US is not just the absence of opportunity for one group relative to another, although certainly that's been a very important part of the story, but also because Black people have had their land actively expropriated from them until remarkably quite recently. So I'm going to now turn it over to Thomas. First of all, Thomas, thank you for being here. And tell us a little bit about the nature of your project, what you have found both in terms of the literature that you've contributed to, and how you've translated that into legislative reforms that have taken place around the country and may soon be taking place here in California.
Yeah, so first of all, thank you so much for the opportunity to talk to the USC's Price School of Public Policy. Thank you, Dean Goldman. Thank you, Richard. It's always a pleasure catching up with you, even though we've been doing it virtually of late, right? It's also, I'm actually a native Californian from San Francisco, proud graduate of Lowell High School in San Francisco. And so let me just kind of situate some of my work. As Richard indicated, as I was a graduate student at the University of Wisconsin, I was doing some research and came across the fact that, and it was a surprise to me, that African Americans had acquired, somewhere between 16 and 20 million acres of agricultural land by 1910, which was a surprise to me, given that the narrative had been that there had been this failed effort to redistribute land to newly freed slaves after the Civil War, the failed promise of 40 acres and a mule. So I was actually surprised that African Americans had acquired that much land by 1910. But that land base has shrunk precipitously. I think when I was beginning my studies in Wisconsin in the late 90s, that land base was down to, let's say, 3 million, 4 million acres of land. So I became curious about what were the drivers of that land loss, and did a fair amount of field research. I actually had a different topic for my thesis, but I happened to be in North Carolina at a meeting of Black farmers, and somebody identified me as an attorney, and these families started coming up to me and telling me about this family ownership that they referred to as heirs property, which is property that people typically inherit when there hasn't been a will. And they started telling me stories of how that property had either already been lost due to real estate speculators preying upon these families, sometimes some interfamily disputes. And they were kind of describing the way this area of property law worked that bore no connection to anything I had learned in law school. And so ultimately I was very polite, but then I told these families I would do some research. And it really took when I came back to Madison from that trip, I looked at every first year property textbook, every treatise. Nothing that these families told me was validated by anything in the case books or textbooks or treatises. But then I asked the families, I said, well, you say there was these court opinions. Can you send me the transcript from these rural county courthouses? Because they're not available in the databases I was looking at, Westlaw and Lexis. And I remember the day they arrived in Madison, and essentially everything these families had told me was true. And so I think that's where I started realizing that this was a much greater phenomenon than I had realized. And I'll just say a quick thing about this form of ownership. It's called a tenancy in common. It's the form of ownership you get if you don't make a will or an estate plan and you leave property with 2 or more heirs. And it's among real estate attorneys or attorneys who do wills, trusts, and estates. It's widely known as being the most unstable form of what we call common real property ownership in the United States, where essentially a group of people own fractional interests in property. It could be land, it could be a single family home in Los Angeles. And the law permits one person in the common ownership structure, irrespective of the size of their fractional interest, to go into court, file a suit called a partition action, and in that partition action, request the court to order a remedy of a forced sale of the property, even if everybody else in the ownership structure wants to maintain ownership. And courts, especially with disadvantaged families, started routinely ordering the sales of these properties, indicating that they were somehow maximizing wealth because theoretically, at least with some of this agricultural land, there were theoretically economies of scale. But in fact, it turns out these sales were what we call sheriff sales or auction sales. Essentially, they were fire sales. And so the family was not only losing its property, but they were being stripped of a substantial amount of their real estate wealth in the process. And when you're dealing with African Americans or Latinos, though it's not good, their asset portfolios are not as well diversified as white Americans. They're disproportionately consist of their real estate or their real property. So when these families suffer a fire sale of their property, it really has a devastating impact. And so, I started in my research and started publishing articles in the early 2000s and are kind of addressing a variety of manifestations of this problem. And I proposed a number of legal reforms or policy solutions. Now, if you go back to the early 2000s, the proposals, my proposals were, I was considered a wild-eyed optimist. I was considered hopelessly naive. And there was some empirical support for that. There had been many attempts in many southern states, at least, beginning in the 1970s, to reform this area of law. And they pretty much all failed. And so people said, you know, what makes you think that you would have any greater success given? And they failed for a reason. They failed because these people lack political and economic power, no matter how unjust the property law is. The lucky break I caught was in the Associated Press got very interested in this phenomenon. They did a months-long investigative report traveling throughout several states in the South. So I kind of overnight, when the AP came out with what ended up being this award-winning story, I went from being, you know, wild-eyed, hopeless optimist to national expert Thomas Mitchell on this area of law. And that motivated the American Bar Association to put together a task force to see what could be done. I was asked to be on the task force. And the most ambitious thing that we pushed was to seek fundamental reform of this state property law, which involved, it's the organization in the United States that's had the longest history of drafting model state statutes. It's called the Uniform Law Commission. Most lawyers don't know it. Most law professors, their eyes glaze over when you mention that. But when I mentioned to at least to lawyers, I said, have you ever heard of the Uniform Commercial Code, the UCC? Everybody, you know, all lawyers know what that is. And I said, where do you think that came from? I was like, the Uniform Law Commission. So the Uniform Law Commission accepted our proposal in 2007 to form a drafting committee to fundamentally draft a new law. And then I was appointed to be the principal drafter. And then, you know, we finished in 2010, and we've had since 2011. We now are up to 17 states and the United States Virgin Islands that have enacted this into law. I think what's most surprising it's most surprising to anybody that we've had any success, because it was viewed as going to be a failed effort. But even for me, it's been a little surprising that 8 of the 17 states are located in the South. We just got in 2020, we got Florida, Virginia, and Mississippi, which I had always conceded would be something that would not be possible for 3 generations. So let me just stop kind of there just a little bit, because I want to make sure that Richard, if you want to prime the pump a little bit.
Sure. So, and before I start asking you questions, I just want to remind the audience that the Q&A box is available for questions to Thomas, and I will try to pass along to him as many as possible before we adjourn for the afternoon. So Thomas, one of the things about these stories is there is some color surrounding them. You described what happened with partition sales in a very scholarly and appropriate way. But if you could regale us with 1 or 2 stories about how these things went. And beyond partition sales, you know, I found particularly interesting how property taxes were used as a mechanism to expropriate property.
Yeah. So, you know, one of the things is I've had to navigate being an academic, but also being very active in terms of the law and policy front, is when you're kind of in the law and policy circles and you're talking to elected officials and other policyholders, you know, it's different than an academic presentation, right? You got to tell a story. And luckily, or maybe not so luckily, because of the abuse in this area, I have a number of stories. You know, so just one thing kind of beginning is just that Hilton Head Island in South Carolina, up until 1950, the majority of the property owners in Hilton Head were African American. And so this property base that I indicated that African Americans acquired up until about 1910, 1920 is, I mean, compared to today, was much more substantial, but the property that African Americans typically acquired was not prime real estate. And Hilton Head back then was not considered prime real estate because there was no easy way from getting from the mainland in South Carolina out to Hilton Head. There was no bridge. And but in the early 1950s, the state of South Carolina built a bridge, and all kinds of real estate developers had visions in their mind of basically what Hilton Head has become. And so they picked off one family after another, to the point that today it's like shocking to hear that in 1950, this property was majority kind of Black owned. Right. There's a family I encountered in my research in South Carolina that was part of a community that actually got land from somebody who had been a signatory to the Declaration of Independence. It's called the Phillips community in rural South Carolina. And about 10 years ago, you had an outside speculator who preyed upon this family, this property that's invested with real deep historical and cultural kind of significance. Picked off one family member who was in Chicago or Detroit or LA. And that's typically what these speculators have done. They pick on somebody who's a distant relative.
And I'm sorry to interrupt, but and they use quit claims in order to do this, correct?
Right. Yeah. And sometimes quit claims, sometimes they buy out their fractional interest. And when they usually do that, they buy out the fractional interest for a low ball price, because oftentimes these distant relatives don't. The first time they learn that they have a 2% interest in the land is when the speculator shows up. And so this is what this speculator did. And then within, a couple of years, they forced the sale of this property. You had property that was, I think the buyout price was, it was like $200,000 for property that ended up then selling a couple of years later for $2 million. And so, you've had that. You've had families I know where it's the, 85-year-old matriarch with the third grade education on their deathbed who has been bought out. So, that's, I've heard that kind of story several times. We've had, one of the things that's interesting, I think, as I made the transformation from just doing purely academic stuff, and then also adding this law and policy, is to, kind of sell our story a little bit. I realized early on in actually the drafting process that I had to generalize this more than just situating this as a problem only impacting African Americans and only in the rural South. So I did some research and ended up finding out that though it's disproportionately an African American problem, it's not exclusively. That there are Latinos in the Southwest, there are poor whites in Appalachia, there are some Native Americans in some states where their property law is governed not by this trust relationship with the federal government, but by the state property law. And then in Hawaii, so while we're trying to broaden the story, let me tell you a little bit about Hawaii. We got our act passed in Hawaii in 2017 with an effective date of January 1st, 2018. On December 31st, 2017, a prominent property owner on the island of Kauai had this huge estate, and as part of his huge estate, there were 8 or 9 properties that were in the interior boundaries of the estate that were owned by these Native Hawaiian families, where he had to grant an easement to the families to have them access their property. He didn't want to do this anymore. He wanted to acquire those properties. So one day before our act became effective, he filed 9 of these lawsuits requesting a forced sale of the property. So if I was his real estate attorney and he had come to me and said, my goal is to force a sale of these properties, it's a perfectly legal goal. I would have told him, you will do better under the old law than this new law. And I probably would have advised him, that's a good thing to do. Now, if I had been his PR person, I would have said, listen, we got some other things to think about. But either he didn't consult his PR person, or his PR person gave him some bad advice, because he did file these suits. And it generated massive amounts of controversy in Hawaii. There were headlines literally that said, this landowner tries to evade protections of this new law that will become effective 24 hours from now. I think you probably have heard of this property owner. He's a guy named Mark Zuckerberg. I'm just thinking that you might have heard of him. He got such bad press about this, and it was such a public relations disaster. He basically dismissed his lawsuits and made it clear he had no intention of trying to forcibly acquire these properties. The last example I'll kind of give you is, for years I've been telling people that not only is this not just a African-American problem, it's a problem that has 4 drivers. The first driver is a very low incidence of making wills. So there's a variety of regional studies in the United States. There's no national study that looks at will making or estate planning rates. And it's kind of impossible to do a national study for methodological reasons, but there's a number of regional studies. So these studies typically show that somewhere between 50 and 55% of Americans make a will. But the will making rates, there is a huge racial will making or estate planning gap in this country, right? So I think the average white family makes wills at the rate of 55%, according to one study from WashU in St. Louis. And the average, and African Americans make wills at the rate of 23%. And the Latino will making rate is very much similar to the African American. One of the things I found like kind of most disturbing is that in every racial or ethnic group, not surprisingly, those who make wills at the highest rate are the more educated. So among white Americans, 73% of white Americans with a college degree make a will. But at least in the WashU study, 55% of white Americans with no high school degree make a will. In the African American community, it is true that African Americans with the highest education, with a college degree or college or graduate or professional degree, make wills at the highest rate. But only 33% of that demographic makes wills. And so you have low rates of will making. You have typically a lack of access to affordable legal services so people can kind of structure their kind of ownership. You have families who are particularly vulnerable, who are low income or low wealth. And then the last driver that really has led to a lot of these forced sales is that, going back to the South Carolina example, the property when it initially was acquired was not considered prime real estate, but over time it's now either newly in the path of development, like Hilton Head was, or in urban sprawl, or it's an area where there's been a rapid appreciation of real estate values, like gentrification in LA, New York, DC. And so I've been making this point for a long time that this is not just a rural problem, but it's also an urban problem. But essentially, almost all the media coverage was about African Americans in the rural South. And I would talk to reporters, I'd make this point, and then the article would come out and be about some African American family in the rural South. Until 2019, there was an investigative reporter for major television station in New York City, NY1. And she did an amazing investigative report of how real estate speculators in almost every borough of New York were preying upon African Americans who had high equity properties, oftentimes because the families got the properties when it was redlined, so they needed a lot of cash. They didn't have financing, but they were now paid off. And she, that article, and that wasn't an article, it was televised. Within a week of that being televised, there was almost a competition among legislators in the New York legislature to see who could introduce our bill the first. And it was a pretty late introduction, early April, and it rocketed through the New York legislature. I mean, some people told me in New York they had never seen a bill move that fast, and it was because of this media story about that. So those are some of the, whether it's the Hilton Head or the Mark Zuckerberg in Hawaii or the New York City. If you have other, flavors, I got an Iowa farm story for you. I've got.
I'm going to ask you about one more, but just a couple of things. One is that New York one story really was remarkable, and I don't know if it's available, if a link is available to watch it. Yeah. But I'm going to ask our team here at Price to make that link available if it is, because the audience should see that story. It was very, very well done.
Yeah, I would say that story, and I was interviewed for Vice, which used to be on HBO, now on Showtime. They did this amazing story of this rural family in Louisiana, and it's powerful. So I like the two of them because one's rural and one's urban.
And then the second thing, there's a question from the audience, and I was going to leave this toward later, but this just dovetails so well with what you just said. There's a debate on reparations for the injury harm caused by racist policies before and after the Civil War. There are multiple proposals out. Do you see establishing estate plans and legal protections for descendants as one remedy? Could this be part of a reparations package?
Yeah, so here's what I'll talk about that, is that, I've been very active in terms of this state law reform effort. And as you indicated, we have now every region of the U.S. from the far west to the northeast to the south to the Midwest to the Southwest. And just yesterday, I think I told you this morning, Richard, the California Association of Realtors has reached out to me, and they want to champion my model state statute in California, which would be great. But part of the success I've had at the state level, I've been able now to leverage at the federal level. There was a couple provisions in the 2018 Farm Bill that were really important. And then just in the last 10 days, Senators Cory Booker, Kirsten Gillibrand, and Elizabeth Warren introduced a bill called the Justice for Black Farmers Act. And in drafting that bill, they consulted with me. And, so we had kind of long, lengthy discussions about it. And so one of the things I made clear is my property law reform is essentially trying to secure and stabilize property rights for people who still own their property. But it does nothing for people who already lost their property. And so if you want a comprehensive solution, you would want something that would provide some type of redress or acknowledge and some type of remedy. You would want to kind of stabilize, property like consistent with like the efforts I've undertaken in terms of my state law reform efforts. And you would also want to identify what are some vulnerabilities these families face that we should put into place resources so that this problem just doesn't keep occurring into the future. So one of the things that just has become just painfully obvious to me in my work is that there is just this chronic lack of affordable legal services for these property owners. And every time I'm in the media, I get just a flurry of emails from families in desperate straits who can't afford a lawyer. And so one of the things that in this bill that's just that Booker, Gillibrand, and Warren has introduced is something like $50 million a year for resources to help these disadvantaged property owning families, and to for the legal services really to target at kind of estate planning. And then secondly, to try to get them to enable them to reorganize their common ownership out of this incredibly unstable form of ownership, this tenancy in common, which many of these families refer to as heirs property, because under the intestacy laws, if you don't make a will, your property goes to your heirs. And this has been so common in these communities that they just they have a colloquial expression, it's called heirs property. And so to have them transfer that property or transform it from this worst form of ownership, common ownership, to something like a limited liability company, or you could have tenancy in common ownership where you are contracting around the worst features of the default rules. So I think legal services is just incredibly kind of important. There's another aspect of this, the Justice for Black Farmers Act, where there would actually be grants of land up to 160 acres for families with a provision of additional technical assistance to enable these families to participate in various federal government programs in a way that would make their property ownership kind of viable. And so that kind of addresses folks who, either families who lost property or people who want to newly get into farming, for example. And then there's like an apprenticeship program where people would serve as an apprentice for a successful farm operation for 3 or 4 years with some government resources in terms of technical assistance and training, so that they would then emerge from the apprenticeship program ready to actually start a farm of their own if they can get the resources to acquire that, or to rent land to be a successful farmer. So, there's a range of kind of solutions. Some of these, whether it's the legal services, that could be the federal government has a role, state governments have a role, foundations have a role, law firms in terms of expanding the type of pro bono work they do, which typically is litigation, not what we call transaction, not real estate or tax or wills, trust, and estate. So the problem is very large, and there's a role for many stakeholders.
I want to ask you 2 more questions, and I'm going to turn it over to the audience. So again, please feel free to use the Q&A box. First, I just want to return to how property taxes were used as a method for expropriation, because for some reason, as outrageous as everything was when we traveled together, that for some reason really hit me. Tell us a little bit about how that worked and how we might make sure that doesn't happen again.
Yeah. So in terms of the property taxes, there's a range of problems with these property taxes. So oftentimes what we have is you have properties that are owned by people of color that their property taxes tend to be overly assessed, and properties among white Americans of some means tends to be underassessed. So you have that kind of structural problem at the beginning in terms of just the carrying charges and maintaining ownership of the property. But then you have examples. There's a huge problem in Detroit now with property taxes, and that's not even like really a racial issue. It's because Detroit has been a struggling city financially, that when the Great Recession hit and property values depreciated, the city of Detroit still assessed the properties as if they were at the high point of the real estate market because they needed money. Even though by the Michigan Constitution, they weren't supposed to do that, they did that. These families often didn't have legal resources to challenge these property assessments that were grossly inflated. And then you've had some problems with families historically that became, like during the civil rights movement in places in Mississippi where families became active in the civil rights movement, and then they got targeted for discriminatory kind of assessments. The issue though, Richard, one of the things that Richard is referring to is we were looking for a field site for this Ford Foundation grant. And so we went to 3 or 4 counties in rural Mississippi and then 3 or 4 in rural eastern North Carolina. So I walk into this county courthouse with Richard and Steve Malpezzi, one of his colleagues at Wisconsin. And we basically present ourselves, and we're this kind of academic team from Wisconsin, and we want to study the economic ramifications of a variety of forced sales. I think we kind of left it. We're trying to be generic, very much sounding like academics. And I said, whether we're talking about partition sales or foreclosure or tax sales. And there was the county register of deeds, was this woman in her mid-60s who had worked in that role for a few decades. I forget her last name, but her first name was BJ, or her initials.
BJ, yeah, that's right.
Yeah, BJ. And BJ said, unfortunately, I'm sorry that you all traveled from so far away because there's no problems in our county with any of these forced sales. And then, but we let her, she was kind of talkative. And then she went on, she said, well, I think one of us said, well, can you tell us how the tax sales work? And she said, oh, and in every state statute with the tax sales, there's got to be notice to the public well in advance of the tax sale. There's rules for governing the bidding. And so we said, for example, like, what are the rules about notice in this part of Mississippi or in the state of Mississippi, to the public for the sales? And BJ, and I can't replicate her drawl because I don't have a Southern accent, but BJ said, oh, no problems with tax sales. And we're far too civilized to go through this process of providing notice to the public because, well, that would be a free-for-all of people showing up. What we do is keep a log of these 3 different real estate companies, and they take turns having exclusive bids on the properties that come up for a tax sale. And that's obviously civilized than having a bunch of people in the room, raising their hands and bidding. I mean, it was just amazing because what she was telling us was totally and utterly illegal. But it had become such the norm there that she didn't have any to say, I shouldn't reveal that we are systematically breaking County, Mississippi. So you have that a window in, there's a gap between what the formal law requires and then what actually sometimes we talk about the law in action or the law on the ground. And that was quite revealing. I mean, I don't want to just pick on the South. I mean, that was a story in Detroit where the folks run Detroit were systematically breaking the law in terms of overly assessing the properties. Now you might think that's a more sympathetic case in terms of their being stretched for resources and feeling like they were constrained, and people can have we can have that debate or discussion or better understanding about the dynamics that led to Detroit doing that, but they were violating the law. So I think that's so that's been a problem kind of with tax sales. I mean, obviously with tax sales too, I mean, what I'm describing is some range of illegality. But then you have in these places where there are obviously gentrifying, a huge driver of kind of, and whether in urban or rural, has been just the property tax assessments going up and these families fundamentally not having the income to maintain or to be able to pay the property taxes as they go up.
So I have an interesting question here about, which is a little off topic, but I think it's worth exploring a little bit, about HOAs and asking, are they the new property tax? Specifically subdivisions designed for uniformity, but restrictive in terms of affordability.
Yeah, so I think that's at least in terms of among property professors, that's something that property professors have been talking about for a few decades. Is should we just allow that and accept that that's just the private market and it should be lightly regulated by the state, or does it have spillover effects in terms of increasing the cost of housing outside those communities as common interest communities become much more kind of prevalent? So I mean, so that's so it's very much, it's one thing if we're dealing with common interest communities and HOAs that are a very discrete and small part of the overall housing market, but that's obviously over the last decades they've become occupying a much more prominent part of the real estate or the housing market, which then does make their types of kind of private regulation that it kind of begs the question, should there be more kind of governmental regulation if it has these kind of externalities? So I haven't looked at the data enough to know, is there like some tipping point where there should be at least a more robust discussion about having significantly or some significant more kind of regulation of these or not.
So there are a number of questions that relate to how do we deal retroactively with these injustices. So, your legislation is an enormous step forward, but it basically prevents bad stuff from happening going forward. And I think this one particular question from anonymous attendee, it puts it quite well. You mentioned the potential of rural land transfers to African Americans. Where do you see potential of restorative justice for city-based folks where land is much scarcer?
Yeah, so I think it's interesting because that, even though my route initially was predominantly in the South, although I broadened it, for academic reasons, but also for my law and policy as I was trying to build a bigger movement across the country for my statute. But initially it kind of started, I'm from San Francisco, and 55 when I was, in 1970 was the high water mark for Africans in San Francisco. 13.5% population was African American. Today San Francisco has an African American population of 3%, and that's disproportionately homeless. And so, and I kind of witnessed when I was there a lot of Americans kind of being pushed out, whether they're business owners, some homeowners, and some renters. So I think that when we're talking about, addressing kind of historical redress, that's tricky, right? Because we're dealing with, especially where there's been gentrification, the property values now are so, they've appreciated so much. It's a very expensive proposition if you're talking about kind of historical redress. And for that reason, I haven't heard a lot of discussion about historical redress, at least in highly appreciating cities, whether it's LA, Cisco, DC, New York, what have you. I've more heard about folks talking about in terms of thinking about different types of ownership structures that would kind of be buffering against gentrification forces. So for example, community land, where these could be either sponsored by a nonprofit, or in some cities like Chicago, they have municipal sponsored community land trusts. So the idea of community land trust is that on the front end is more affordable because you have kind of a ground lease, and the ground lease is separated from the structure itself, and the ground lease gives the association the ability to put some controls on the property, and the chief control is they cap how much appreciation you can get when you sell the property. So you can't capture the full market value. You can capture some of the appreciation, but not all. So it makes that unit more accessible over time. I think when I began this work in the early 2000s, you had foundations like the Ford Foundation that were not very supportive of community land trusts because they thought it was not a good tool in terms of generating wealth, because they saw that it artificially capped. But I've talked to some people who've been working with the grantees of the Ford Foundation in the last few years, and the Ford Foundation, just as one organization, seems to have changed a little bit of its opinion on the merits of a community land trust. So I think, so I don't have any, if we're talking about places where folks were displaced, usually that was displaced because the property values just skyrocketed. And then, I haven't, and I'm not saying that there aren't proposals, I'm just not familiar with any proposals that in any significant way talks about trying to provide redress for families who, were pushed out either illegally or just because of gentrification in terms of the rapidly appreciating real estate prices.
So we have a few minutes left, and I'd kind of like to finish on a happy note, given that these are not particularly happy times. I just want you to take us back to your experience getting legislation done in Mississippi. And I know that that really pleased you.
Yeah.
When it happened. This is a policy school. People care about how policy is made. Take us a little bit through how that actually happened.
Yeah. So I think when I started off in my research, it was very much, I think property scholars, very much value my research because they thought it was, incredibly thoughtful, detailed, subtle. But it was definitely, there was an overarching kind of racial justice theme to it. And it was really in the drafting of the this Uniform Act that I realized that politically I was going to run into some problems. And the problem, just even in the drafting, was that I heard from, so these, when I say the Uniform Law Commissioners, there's 350 people in the country called Uniform Law Commissioners. They're all appointed by governors. So they're politically connected people. And I had a couple, about halfway through the drafting process, it was a 3-year process, somebody pulled me aside at one of the meetings and said, listen, there's a problem with your act. And people are saying it's the Black Act by the Black drafter. And I'm, in the 128 years of the Uniform Law Commission, I'm just the second African-American ever to have served as a principal drafter. And the message was your act is getting marginalized and it might actually get killed in committee. So that's where I realized I've got to be able to reframe this as not purely an African-American, but a story that this impacts a number of families, and going back to my data about will-making rates, but maybe disproportionately African-Americans and Latinos. And I really learned that lesson when it came to trying to go state to state to get this enacted into law. So what I learned, especially in the South, but not exclusively in the South, was that when I had to testify before a legislature, my story had to be that this is a problem that impacts all kinds of communities, racially and ethnically, whether it's rural or urban properties kind of implicated. And then I had to, frame, well, what is this about? And I fundamentally realized when I traveled I testified in some of these legislatures that my story needed to be that this is fundamentally about enhancing property rights for these families and protecting their real estate wealth. And that just became my kind of mantra. And I think there's a couple of states where that was the game plan. You know, I was in Texas a few years ago when we were getting it, when I was testifying in the Texas House. And I saw that this was the House Judiciary Committee. There was a consumer protection bill up before my bill, and really smart public interest attorney. And a third of the members of the House just savaged her. They went after her mercilessly. And I remember saying, I just got to stick to my story, but I need to prepare myself that I might have these 3 or 4 guys just brutally come after me. But I'll say, you know, we'll see how it goes. And, you know, but a minute into my presentation, I said those 3 things I just told you, and all of those guys were nodding, you know, like in agreement, uniform passage. Let me just tell you the story about, I'm going to move you from Mississippi to South Carolina. So South Carolina, in about 2016, we introduced our bill. I testified in the South Carolina House. It seemed everything was good. We got a unanimous vote out of the subcommittee of the House Judiciary Committee there. And folks told me after, as I was leaving Columbia, that with that kind of vote in the subcommittee, it was going to sail through. Well, about a week later, I was at a conference at University of Georgia. I got an email that said, your bill is dead. And a real estate developer apparently had gotten to the chair of the House Judiciary Committee, and he was putting a hold on it. We overcame that through some Hail Mary passes I threw, and that paid off. But then it went to the South Carolina Senate. Once again, the people I was working with in South Carolina said, everything's going well until it wasn't. And I got an email that said, or a phone call that said, there's 2 state senators that have severe problems with your bill. So our game plan was to have they were going to identify the issues that came up in that colloquy with those senators. I would write a memo addressing those concerns. They would be distributed to every member of the Senate Judiciary Committee in South Carolina. And as a result of my memo, it basically convinced one of the 2. And so he was then going to support it. But the last one was a state senator named Paul Thurmond. His dad was some guy named Strom Thurmond, and he was hell-bent on killing our bill. And this would be a little Ask More story I tell. So this goes back to, I think it was in 2016 or 17, where there was that massacre at that Charleston African AME church. Mm-hmm. The pastor who was murdered in that massacre also was a state senator. And he was a state senator known for being most concerned about improving property rights protections for disadvantaged South Carolina property owners who were, disproportionately but not exclusively African American. His name was Clemente Pinckney. So at the last minute, because Paul Thurmond was hell-bent on doing everything he could to kill our bill, the sponsors in the South Carolina Senate renamed it the Clemente Pinckney Uniform Partition Act. It's the only bill that the South Carolina legislature has ever named after Clemente Pinckney. And essentially, there were a number of state senators who were on the fence, but they decided they were not going to vote against the only bill honoring Clemente Pinckney. And so as a result, the only person to vote against it in the South Carolina Senate was Paul Thurmond. It kind of sailed through. As a result of it being named in honor of Clemente Pinckney, then Governor Nikki Haley invited me to a ceremonial signing in her office with 2 other people. But I mean, it's kind of, it's obviously a sad story what happened at that Charleston church, but part of me is happy that at least we have honored the heritage of Clemente Pinckney by using his name to help get our bill over the line.
So Thomas Mitchell, thank you very much for spending some time with us this afternoon. Really interesting and inspiring stuff. Let's make things even better going forward. I want to thank Dean Dana Goldman for arranging this. I also want to thank the Price School Office of External Affairs for doing the wonderful job they always do to organize this. And Dana, you want a last word?
No, just fascinating discussion. Thank you both. Really appreciate it.
Thank you, everyone, for joining us.